So what's the impact going forward here? Um, so some key issues. So employers who have arbitration agreements, you need to review them and make sure that they're up to date to comply with this Viking ruling. And then, if, like I said, up until 2 weeks ago, Viking or Iskanian, the California Supreme Court ruling that these PAGA waivers were invalid was the law of the land. So many agreements currently do not, or they carve out these PAGA claims and allow them to proceed in court. So employers need to take a look at them and potentially adjust them, modify them to say it's a class action waiver and the PAGA waiver. And again, you need to work with counsel and make sure you've got all the elements that were found in the Viking decision, in the Viking Rivers arbitration agreement as well, the severability clause as well. So if you don't have an arbitration agreement, you need to evaluate the pros and cons of implementing an arbitration agreement. Generally, we like them, especially for larger employers. Now, given this new decision, they have even more teeth. But there are some pros and cons with arbitration agreements. And for that, I'll hand it over to Mike.
Yeah, and we got one question from Peter asking, if we don't have an arbitration agreement in place, is there any impact of this case on us besides, implementing these in the future? And I think the answer to that is if you don't have arbitration agreements, this case doesn't really change anything currently, but it's a good idea or prompt for you to consider whether arbitration makes sense for you as an employer. And it's not always going to. For a lot of employers, it makes a lot of sense, but some employers, it may not make sense. And so some of the pros of having arbitration agreements is you can include, class action waivers where the employee agrees, that we'll resolve our claims on an individual one-to-one basis in arbitration. The PAGA waiver, you can, waive the right to have that arbitration be anything other than, one-to-one. It does, the existence of an arbitration agreement does affect a plaintiff's counsel assessment of the case. And that can be really important to keep in mind. The most common way that you'll find yourself in a wage and hour claim is you'll get a records request where an attorney will request the personnel file and payroll records for their client. And if the personnel file that you produce includes an arbitration agreement, that does have a meaningful impact on whether the plaintiff's counsel is going to pursue the case at all, or maybe, try to settle it early. Arbitration can be faster than the courts, especially with some of the courts' COVID-related burdens. You can have more confidentiality. The arbitration hearing is usually in like a conference room, not in a public courthouse. Discovery is streamlined and fast and cheaper. There is you can waive the right to a jury trial, and so in connection with that, you can have an arbitrator who is actually a subject matter expert. Someone who deals exclusively with employment issues, wage and hour issues, versus a judge who may come from any background, probably a district attorney, and a broader range of experience. But the cons are, these arbitration agreements are subject to challenge by employees, and so that will typically mean the employee may file initially in court and force you, the employer, to bring a motion to compel arbitration and spend the cost to try to get into arbitration. The law is constantly changing, and so you're going to need to regularly review your agreements to make sure that they are up to date and compliant with any new decisions that come down. The employer, is expected and required to pay the extra costs associated with arbitration. The judge in your civil case is paid by the state. The arbitrator is a private judge that is paid by the parties. And in an employment context, that means the employer is paying the cost of the arbitrator. And there's limited judicial review of the arbitrator decision, which can cut both ways. But if you prefer to have more appellate review, arbitration may not be the best choice for you on that.